LawSikho's thorough newspaper analysis for 13th of October 2023. चलिए आज की एजेंडा की तरफ चलते हैं. We'll be giving an update on the previous editorial that we took was related to money bills validity. So 7-judge bench to take a call on giving priority to money bill case, which we have taken from the Hindu. Then we'll be talking about some interesting news update and legal news update coming from Honorable Supreme Court and High Court of India. Chale, let us start with the editorial section. Previously, in the past TNAs, we have discussed that the Supreme Court would be taking a call on the Prevention of Money Laundering Act, that whether it is categorized as money bill and whether the Speaker's decision is final or not, and it would be going before the 7 judges bench. Now, in this particular editorial, we'll be talking about the requests that have come up from the petitioners before the Honorable Chief Justice of India to take up the case on priority concerning the manner in which the centre got crucial amendment passed in Parliament as money bill. So, the request has come up to take a call on priority. Now, against this, the centre has objected, saying the bench should not give priority to the case based on the request made by petitioners, which include one of the Congress leader, Mr. Jairam Ramesh, on the basis of political exigencies. Now, the reference include legal questions concerning amendment made from 1950 onwards in the PMLA, that is Prevention of Money Laundering Act. And in this particular act, the Enforcement Directorate has been given blanket powers of arrest, searches, and so on. Though the court upheld the validity and the legality of PMLA amendments, it left the question whether the amendment could have been passed as money bill to the 7 judges bench. So the legality and the validity of the amendment remains intact, but whether the bill which has been passed as money bill should have been passed as a normal bill or not, that is the question and the issue here. Similarly, the case also raises question about the passage of Finance Act 2017 as money bill to alter the appointment to 19 key judicial tribunals, including National Green Tribunal and Central Administrative Tribunal. Now, Mr. Jairam Ramesh has argued that the 2017 Act was deliberately categorized as money bill because to extend executive control over these institutions by altering the composition of selection committees, vastly downgrading the qualification and experience required to staff this body. So one of the petitioners, which is Congress leader Mr. Jairam Ramesh, has argued that the 2017 Finance Act, which related to 19 key judicial tribunal appointment, is deliberately being categorized as money bill. The 7-judge bench is hearing the money bill question based on the reference made in November 2019 by a 5-judge bench, which then headed by Chief Justice Mr. Ranjan Gogoi in the case of Roger Matthew versus South Indian Bank. Now, the cardinal issue here is whether the amendments which are being passed as money bill, now circumventing the Rajya Sabha, is in the violation of Article 110 of the Constitution or not. So the issue here is the bill that would have been passed normally passing through Lok Sabha and Rajya Sabha has been categorized as money bill, and the money bill has been categorized circumventing the Rajya Sabha and it has been passed as money bill is in violation of Article 110 of the Constitution or not. Now, what is money bill? So money bill is deemed to contain only provisions which are relating to the matters under clauses A to G of 110 article, which largely includes the appropriation of money from the Consolidated Fund of India and taxation. In other words, a money bill is restricted only to specified financial matters. Now, a money bill reference is numbered 5 in the list of cases scheduled before 7 judges. So, there are number of cases scheduled before 7 judges and it has been listed on the 5th number. The bench had convened on Thursday to iron out the pre-hearing formalities before the cases were to be heard. The question of passage of laws after dressing them up as money bill had come up in the Aadhaar case too. Justice, the two now, however, the top court had in the majority verdict in 2021 refused to review 2018 judgment upholding the validity of Aadhaar Act and its certification as money bill. Honorable Justice D.Y. Chandrachud and present Chief Justice of India, who is heading the current bench, had delivered a dissenting opinion on the review bench. Now, the two questions before the review bench had been whether the Lok Sabha Speaker decision to declare the proposed Aadhaar law as money bill was final, and whether the Aadhaar Targeted Delivery of Financial and Other Subsidies Benefit Services Act was correctly certified as money bill under Article 110, subclause 1 of the Constitution or not. So before the review petition, the 2 point of issue were in consideration. Justice Chandrachud in his dissent had said the review bench ought to wait till the 7 judges bench decided the larger question on money bill in the Roger Matthew reference. The majority led by Justice A.M. Khanvilkar, retired justice, has disagreed with him. So in the Aadhaar case too, this particular question came up. The review petition was being, it was not being accepted, but the review bench was dissented by Honorable D.Y. Chandrachud Justice. Now, the question would be heard by the 7 judges bench, and whether the bench would take it on priority is a matter of question, and it is up to the bench to decide. So we'll keep you updated by all the following amendments that are coming up and what are the current happenings before the honorable bench of the Supreme Court. But this is something which needs to be taken care of, because to categorize as money bill, and if it deems to be unconstitutional, it creates a big question mark that where we are heading to. So yes. Now let us continue with the national news of the day. Now, India re-elected as the president of Asia Pacific Institute of Broadcasting Development for the 3rd successive term. Now, Asia Pacific Broadcasting Development is established in 1977 under UNESCO, and it's a unique regional intergovernmental organization having 92 member organizations from across 44 countries. So for the 3rd time, India has been re-elected as a president for Asia Pacific Institute of Broadcasting and Development. Okay, chale. National Games 2023 is scheduled to be held in Goa from October 26 to November 9. So National Games will be held in Goa. The Technical Committee of the Indian Olympic Association had tentatively announced the dates for the 37th editions of the National Games late in June, pending confirmation of the daily schedule. Now, the National Games were first held in Lahore, undivided India, in 1924 and were known as Indian Olympic Games until 1938. National Games 2023 will mark the debut of several new sports, including beach football, roll ball, golf, and squaw martial arts and penaxilate. So it is something that is happening in Goa this year. Second spaceport of ISRO to be set up at Kulasekarapattinam in Tamil Nadu. The second spaceport of ISRO, which will be dedicatedly exclusively for small satellite launch vehicle, will be set up in Tamil Nadu. Now, manufacturing park to come up near spaceport. So Dr. Goenka also said that a small space manufacturing park would also come up near the spaceport in Kulasekarapattinam. At present, ISRO has one space station, that is Satish Dhawan Space Center in Sri Harikota, with 2 launch pads from where the rocket launching operations of PSLV LMV-3 are carried out. So new second spaceport coming from for small satellites. Now, Ayodhya gears up to host National Archery Championship. So after a successful showing at ongoing Asian Games, almost all Indian top archers are expected to be seen in second National Archery Championship, which is scheduled in the month of November in Ayodhya. Now, a government communique has stated that around 1,100 participants, including 550 women archers from across the country, will take part in the 6-day championship. The championship will be played in individual, team, and mixed team event under Indian Reserve and compound rounds. So, Ayodhya gears up for the National Archery Championship. President inaugurates International Conference from Research to Impact. The President of India, Srimati Draupadi Murmu, inaugurated an international research conference on From Research to Impact towards just and resilient agri-food systems. The President said that at a global level, we have seen that women have been kept outside the agri-food systems for long. She added that they form the bulk of the lowest pyramid of the agricultural structure, but they are denied the opportunity to climb the ladder to assume the role of decision makers. Now, it's a very international conference from research to impact, and it relates to agricultural thing. The 4-day conference was organized by the International Agricultural Research, Gender Impact Platform, and Indian Council of Agricultural Research in New Delhi. So this is happening in New Delhi and relates to agricultural research and gender impact platform. Now, India, Italy signed pact to deepen defense cooperation. So India and Italy have signed a defense cooperation. The agreement will promote a bilateral cooperation in areas such as security, defense policy, research, development, education in military field, maritime domain awareness, sharing of defense information, and industrial cooperation. The relationship between India and Italy was elevated to strategic partnership in May 2023 during the visit of Italian Prime Minister Giorgia Meloni in India. So, India-Italy signed pact to deepen defense cooperation. Bangladesh PM Hasina inaugurates largest infra project built with Chinese loan. Bangladesh Prime Minister Sheikh Hasina has inaugurated a 82-kilometer Padma Bridge rail link, the country's largest infrastructure built under China's Belt and Road Initiative. Hasina unveiled the Dhaka and the Bhanga section of the rail route between Dhaka and Jaishankar to the Padma Bridge from Mawa railway station in Munshi Ganj. A remaining portion of the project linking Jaishankar is expected to be launched in June next year. Now, international news. Sri Lanka hosts IORA, that is Indian Ocean Rim Association, ministers meeting in Colombo, and Jaishankar set to attend the same. The Council of Ministers is the highest decision-making body of Indian Ocean Rim Association, the largest and the preeminent organization in the Indian Ocean region with 23 members and 10 dialogue partners. Now, Sri Lanka assumed the chairmanship of IORA for a period from 2023 to 2025 at the 23rd Indian Ocean Rim Association Council of Ministers meeting to be held in Colombo. Now, the legal update coming from the Honorable Supreme Court in the case of Naresh Nehru versus State of Haryana. It relates to Section 149 IPC. Prosecution must prove accused was aware of offences likely to be committed to achieve common object. So Supreme Court has emphasized the importance of concrete evidence to establish the common object in cases involving Section 149 of the IPC. This provision deals with vicarious liability of members of an unlawful assembly. So prosecution have to credentially prove accused was aware of offences likely to be committed to achieve common object. Section 149. It's a very apt question for judicial services, as you all aware. Like every now and then on Section 149, a situation-based or a direct theoretical question comes. So it's an important judgment for your examination perspective. Now, Bombay High Court calls for progressive view on obscenity, says wearing short skirts, dancing provocatively, not per se obscene. Women dancing proactively in skimpy clothes or making gestures are not obscene or immoral acts which could annoy someone. The Bombay High Court Nagpur bench was held in Lalit, son of Nandalal Bayes versus State of Maharashtra. It's a very revolutionary judgment coming from the Bombay High Court. The court held that in present time it is quite common and acceptable that women may wear such clothing or may be clad in swimming costumes or such other revealing attire. We often witness this manner of dress in films which pass censorship or a beauty pageants held in broad public view without causing annoyance to any audience. Surely, the provision of Section 294 IPC would not apply to all these situations. We have considered opinion that the acts of accused female dancers referred to in complaint FIR, namely wearing short skirts, dancing or making gestures that the police official considered obscene, cannot be termed to be per se obscene act, which could cause annoyance to any member of the public. A very revolutionary judgment coming from the Bombay High Court. And yeah, that's all for the today's news update. Thank you for watching. Take care.